Today's courtroom drama takes a shocking turn. A defendant facing the most serious charges watches his fate shift from decades in prison to just a few short years. You'll see the judge break down legal loopholes, a deal that changes everything, and the exact moment the guilty plea seals his future. Trust me, you won't want to miss a second of this case. And hey, if you love real courtroom breakdowns like this one, make sure to hit subscribe so you never miss the next twist.
I'm looking at the indictments which allege first-degree felonies of sexual assault of a child. We're going to vote on attempted.
Yes, sir.
Isn't that 1 degree less?
Yes,
But these are third degrees. From a first degree to a third is not 1 degree less.
the agreement was to drop the first degree enhancement. There's an enhancement in the indictment.
What
It's
is
the first? It alleges
The child being under the age of.
Pause right here. The judge is carefully untangling the indictments. What started as a first-degree felony, the most serious, just got negotiated down. This is classic courtroom chess. Prosecutors drop enhancements, and suddenly the defendant's potential prison time shrinks dramatically.
I think. What is it?
younger than 17?
It's the familiar relationship.
Oh, is it? Let me say it.
It alleges a familiar relationship.
I don't think.
It doesn't. Does not.
I think it's just.
Yes, but he was like, oh, that makes sense.
Can I see the indictment, please, sir? I don't have my file. Can I see your indictment? Yes, sir. There's an enhancement down here under this last paragraph here. It says has a familiar relationship or prohibited from having sex with because of that relationship. So we're abandoning that and just proceeding on the second degree and then dropping it down to a first degree. This that prohibited from having sex under 2502, I believe, or something along those lines.
Oh.
That makes it a first degree.
Oh.
So we're just
Okay,
abandoning
it
that.
doesn't-
We're abandoning that language,
it
making
doesn't
it.
say it just referred to the statute.
Yes, sir. And we're just making it a second degree and then reducing, doing an attempted. So I'm abandoning the language of the familiar part.
Okay. Well, there's no language that says that, but it just refers to the general
Yes,
section of 2502.
Yes, sir.
And this is 429. What are we going to do? 430?
Same thing. Same exact thing.
Okay, in each of these cases, does the defendant waive formal readings of the indictments and the arraignments here? Can we proceed in summary?
He doesn't with my earnings.
In summary, in cause numbers 23 CR 429 and 430, in summary, these indictments allege that on or about June 1st, 2020, in cause number 429, and on or about August 31st, 2020, in cause number 430.
Did you catch that? The defendant is essentially trading a possible life-crushing sentence for a plea that caps out at just 3 years. This is the power of plea bargaining. Swift, strategic, and often controversial. What do you think? Should deals like this even be allowed in cases involving children?
In Jefferson County, Texas, it is alleged you committed the first-degree felonies of sexual assault of a child. Do you understand what you're charged with in each of these cases? Agreements have been reached in each of these cases. You will be pleading guilty to the lesser included offense of attempted
sexual assault of a child. Yes, sir.
sexual assault of a child. In each case, which would be third degree felonies in the way the case is indicted under section 2502, that would be dropped,
That is abandoned. Yes, sir.
abandoned by the parties. So the lesser included offense becomes a third degree felony. of attempted sexual assault of a child under these circumstances, which means in each of these cases you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement has been reached. Whatever sentence shall not exceed, is that 3?
Yes. My handwriting.
Yeah, it's sort of. Whatever sentence shall not exceed a cap of 3 years in prison. So what we have here are the options, which would run concurrently with each other. So you're looking at no less than 2, no more than 3 years confinement in prison.
That's correct.
That's deferred or unadjudicated probation could be assessed. Is regular probation
I don't think
an
so.
option under these circumstances?
I don't know if this is attempted, it might be.
It's involving a child less than 17.
10 cells usually are 3G as well, right?
Not necessarily.
Here's where it gets tricky. The judge mentions probation, but with child-related cases, probation is not always on the table. That's why the lawyers are dancing around the statute numbers, because one wrong phrase could mean years behind bars instead of walking free for the defendant.
Anyway, there's going to be a plea agreement, a pre-sentence report prepared. We will all come back, review it, make sure that it's true and accurate. Each party gets to sound in, and then the court will make its decision. Is that your understanding of what's going to happen?
Yes,
If I follow this agreement, you have no right of appeal. Do you understand?
yes, sir.
And again, how do you plead here for this lesser included, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? All right, I'm going to show you what's marked as State's Exhibit 1. Did you sign that document? Yep. Voluntarily, understand it, discuss it with your attorney, or the content's true and correct. State's Exhibit 1 is tendered into evidence and without objection submitted. Among other things, this states you are mentally competent to enter your guilty plea. It's free and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of this crime and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination.
And there it is, the defendant's guilty plea. No jury trial, no witnesses, no cross-examination. Just a signature and a yes, sir, to the judge. In moments like this, justice feels less like a dramatic showdown and more like paperwork sealing a man's fate.
Of witnesses, and you were totally satisfied with the representation provided by your lawyer, and all of this is true. The state still help you God. State's Exhibit 1, part of the record for all purposes. All pre-sentence report will be prepared. Come back on
July 15th.
July 15th. Everybody will sound, and the court will make its decision. Do you understand? Okay. That is all. Get a reset.
Yes.